guys all right just giving a knock or a nod and I'll say authorised, thank you?
Yeah.
Alright. Well, how is your next week looking? Yeah. Pretty much the same. I think we're going to be doing a Skype hearing on Tuesday and then possibly in person. Wednesday or Thursday. Yeah. This lockdown looks introduced a bit seriously as the last one. To be honest, like the last one I lived with housemates, they all ran off to the countryside. So I had like the whole house to myself for 3 months. Right, I can work here, I've got an office, you know, living room, bedroom and stuff like that. This time you've got housemates, they're all staying in London. The house full of people. Coming in here is yeah.
Everything that you saw was like more shutters down on the shop.
I know. It's like I really want to go into the Christmas with my family this year. And I just pray that it's so bad for Christmas that I'm not going to be able to.
I don't think it's do you?
No, absolutely not. Boris doesn't want to be the Prime Minister who cancelled Christmas. Is your just pretty good?
No, no, it doesn't. It doesn't.
It's the first paper hearing about in a while. Like without anything to
Oh,
do with
right, okay. So you've just been getting all the electronic stuff.
Well, even if he'd been in court, he's been doing it on laptops.
Oh,
Yeah. Like, so getting papers to him during, if he is going to be at home, I've said that I'll just cycle down to him. Like,
Yeah.
it's like, I've had so much stuff sent to this building. It's like just God disappeared. It's not the poster was wrong. It's just it's addressed to like the court manager, RCJ. It's like, where's it going to go? You all three? Yeah, yes, right. I think it's live streamed at the moment, don't we? We're on the stream right now.
Yeah, oh yeah, I know. I noticed that they put it on really early.
That's why like you go away and masks are cool. Have some member of the public. I saw them. Lost their masks.
There's only 2 here at the minute. There's only 2 here at the minute.
What, to push in chairs?
No, there's only
judges.
2 judges here at the moment.
Oh,
We're still waiting for it.
Are you alright? Because I'm not meant to come up.
No,
on
no,
the
no.
bed.
Yeah,
That's fine.
they're going to sit themselves.
That's what I thought you were.
Oh, well, I'll seat mine anyway. That's not a
Alright,
problem.
bless you.
Oh, I think my judge has no seating. So
What do you mean, like all of us?
Yeah, they can sit themselves.
Oh, okay.
And that's the way. Well, that's the way I've been doing it. My judge, he said, don't bother.
Oh, okay. Well, I've been seating mine.
Well, if I'm not, I don't want to look like a. I don't want to not do it.
So do you want me to not to bother with it?
In that case, I'll just do it. He can complain to me later if he's upset about it. He won't be upset. Nobody even knows.
Silence. Calls rise. Appeal in the matter of J. Simpson and Cantor Fitzgerald Europe.
Yes, Mr. Reed.
Thank you, my lord. My lords and my lady, I appear on behalf of Mr. Simpson in this appeal. My learned friend Miss Mayhew appears on behalf of Cantor Fitzgerald Europe. But both I mentioned by way of background, you may have appreciated both I and Miss Mayhew appeared initially before the Employment Tribunal and before the Employment Appeal Tribunal and before your lordships this morning.
Yes.
With that brief introduction, of course, I observe that this is my appeal. Strictly an appeal against the decision of the Employment Appeal Tribunal, the President sitting alone on the 21st of June, and that itself was an appeal against the decision of the Employment Tribunal, sitting as a panel of three, of the 17th of July 2017, under the chairmanship on that occasion of Mr. Pritchard. Can I give one small point of housekeeping and apology, as in this was due to come onto an appeal earlier in the year, and perhaps understandably for understanding, it came off again. And in the process of re-preparing it, I realised that I'd made an error, and that the copy of the closing submissions before the Employment Tribunal below, which were included in the appeal bundle before the EAT, to which there's a reference, hadn't been included in the appeal bundle for your lordships. Yesterday I sought to correct that. I spoke to my learned friend about it. She was content for me to send that in. I offered her the opportunity of including her own closing submissions before the Employment Tribunal, but she didn't feel it necessary. So hopefully you haven't been burdened too much by paper, and I'm going to make a brief passing reference to how the case was put at first instance.
By all means, Mr. Reed.
Thank you
well,
very much.
I can offer a counter apology, which is that this was sent in by email yesterday. My clerk forwarded it to me. I read it, but I haven't printed it out. So you may have to remind me if you want to look at the contents. You may have to spell them out rather slowly. But
That's absolutely
but
fine.
no
I brought hard copies, but I understand we're not allowed to pass hard copies up. So, I'm happy to give you the reference and read the relevant passages when we come to that particular position. Returning briefly to an overview, and it's set out by way of background in my skeleton argument. And although I might be criticised for making what's more of a forensic point than a legal point, the background to this particular case, as far as the claimant was concerned before the Tribunal, was that he had a very short career with the respondent entity. He worked in relation to the emerging markets desk, and his employment spanned the period between the 28th of February and when eventually he was effectively dismissed on the 31st of November, notice having been in that short period.
31st of December.
I do apologise, 31st of December. He was given notice on the 31st of November and it took effect.
31st of November doesn't exist.
You're quite
steady
right.
on, Mr. Reed. You mean the 1st of December?
I mean the 1st of December, sorry. And in the intervening period of time, his probation had been confirmed, and his case was that his dismissal, that didn't follow any form of disciplinary process, had been the product of, and was for the principal reason and therefore automatically unfair, that he'd made a succession of protected disclosures, and importantly on his case, progressively from his line manager raising concerns about the emerging markets desk to more senior management and then to compliance. There was also a claim based around detriment in respect of the way that he'd been treated prior to the giving of notice. With retrospect, perhaps as an advocate before you, reflect back that when I described the judgment being not a conventional judgment of the Employment Tribunal, I'm perhaps coyly rather polite about it, because from the perception of the appellant, the judgment of the Employment Tribunal doesn't really reflect much at all of the typical structure of an Employment Tribunal judgment in reflecting, as we would say, clear findings of fact as an analysis, a clear articulation of the principles of law and an application of the principles of law. And a primary ground of appeal for us is the failure to comply with Rule 62 of the Employment Tribunal rules. And that's not a point which is presented as being a formulaic obligation, and I'll deal briefly with the case law in relation to it. We say that the reality is when one starts to look at the legal tests that had to be applied and how the judgment has merged those legal tests in with findings of fact, it's hard to see that the tribunal has properly directed itself as to the law and then applied that to specific findings of fact. Now, I acknowledge, and I didn't indicate at the beginning, of course, my Lord Justice Bean gave permission for this appeal to proceed, and I acknowledge that his permission expressed some hesitation about giving permission and did so noting that there were trenchant findings of fact. I can't ignore the fact that the tribunal didn't form a favourable view of my client before it, and there are some strong findings made in relation to him, but that doesn't prevent one concluding that if those findings of fact, if one can see within them indications that actually the tribunal has misapplied the law in the approach in relation to that, unless one can entirely extract the findings of fact and see there as being a freestanding basis on a correct application of the law, that really is a fundamental problem in relation to the judgment. And really that comes back to the first point I'm making, which is about the failure to comply with Rule 62 of the Employment Tribunal rules. I won't, for present purposes, take you to the bundle of authorities to take you to the rule itself, because in my skeleton argument I cite all that's relevant in relation to it. And Rule 62 of the Employment Tribunal rules sets out certain issues for a tribunal, certain matters for a tribunal to deal with in its judgment. And Rule 62 subparagraph 5, I should say I'm reading here from paragraph 9 of my skeleton argument. Those reasons shall, and I emphasise the word shall because it's an obligatory requirement, identify the issues which the tribunal has determined, state the findings of fact made in relation to those issues, concisely identifying the relevant law, and state how that law has been applied to those findings in order to decide the issues. Now, I entirely accept, and the Employment Tribunal approached this on the basis that that wasn't something which required a straitjacket as to a particular form, and if there was substantial compliance with those obligations in the form of the judgment read as a whole, that would meet the test, even if one didn't see a clear delineation between specific parts of the judgment. I'll take you in a moment to look at a case of the EAT, which, although of course isn't binding upon your lordships, I respectfully submit accurately summates the correct legal approach to that question. But just pausing there in relation to matters, it's quite clear from the judgment, as your lordships will have read it, that we don't see anything like that in terms of its structure. We see one case referred to on 2 occasions. We don't see, perhaps rather surprisingly, an articulation of the statutory test that has to be applied in relation to matters at any particular point in the judgment. And we don't see any consideration of what, with respect to the learned judge, are some vexing decisions even at the time that have been passing through the courts. As we go to the skeleton argument, there are at least two issues where matters were progressing to the Court of Appeal about issues about the correct interpretation, and those were cases which were before the Employment Tribunal, certainly on both my part and I think my learned friend's part, but we don't find any analysis or nuance in relation to some of those particular issues. Can I then take you, as I say, strictly not binding upon your lordships, but helpful, I think, just to set out a couple of points about substantial compliance to Greenwood and NWF Retail Limited. It's tab 7 in the bundle of authorities. This is a judgment of the Employment Appeal Tribunal presided over on that occasion with by His Honour Judge Hand, and as certainly Lord Justice Bean will be familiar, it bears all the characteristic hallmarks of the very detailed and considered approach of Lord Justice Hand in, of His Honour Judge Hand in looking at the law and analysing the approach. And just as by way of background, and we'll see when we look at the judgment these issues arise, historically there hadn't been a rule in the original rules of procedure of the Employment Tribunal that quite articulated the way that the obligation in Rule 62.5 articulates it, until 2011, when there was, 2003, when there were a new set of rules in the Employment Tribunal, which, although under a different numbering, included a similar obligation. Prior to that, there had been quite a body of case law about what was necessary for an employment tribunal to articulate the reasoning for its decision, and also some common law decisions, most notable of which was the case of Meek and the City of Birmingham District Council, which is a case oft referred to in the employment tribunal.
We know about Meek.
You know about Meek, yes. The only point I make about Meek is that Meek predated the change in the rules. And so one of the things that was being considered by the EAT in Greenwood was how one looked at the context of Meek and then the obligations which the rules now impose. Did it change the pre-existing law, or did it put in place a more specific articulation of an obligation? And His Honour Judge Hand undertakes a detailed analysis of the law, and I don't need to take you to the case, but in particular including an analysis of the decision of the Court of Appeal in a case called Balfour Beatty Networks and Wilcox, and addressing those facts as concludes from that, and I don't take issue with this, that substantial compliance is the test. And then, can I specifically in his judgment take you to page 916 and paragraph 63. And as I indicated, this reflects his analysis of the law from Meek and the earlier judgments, Balfour Beatty and substantial compliance, and looking at how those matters should be read together. And as I indicate, while acknowledging it's not binding upon your lordships, it's an analysis which I adopt for the purpose of what substantial compliance means. Since 2004, Rule 30, subparagraph 6, and that's what the form of the rule that we now have in this appeal, has set out the contents of a decision should be. In our view, the continuing utility of Meek relates to issues as to whether there has been substantial compliance with the rule. It seems to us that what Lord Justice Buxton kept in mind when considering whether there had been substantial compliance within Rule 30, subsection C and E in Balfour Beatty. Substantial compliance with the rule can only be achieved by sufficient detail in respect of each of its components as enable a party to understand the conclusions reached and how their application has resulted in the outcome. It seems to us that however closely Meek may resemble English, that's a reference back to the case of English Reinbold, tribunals would be better to refer to Meek, which is a Court of Appeal decision relevant to this jurisdiction. Furthermore, without attempting to lay down any rigid guidance and mindful that all the sources of cases are different, we think that most cases are likely to call for a rather more explanation than envisaged by the last sentence in paragraph 19 of the judgment in English. So just pausing there, what we draw from that is this, that read together, it's important to recognise that there are discrete elements of the obligations on the tribunal. There are obligations about stating its findings of fact, obligations about concisely identifying the relevant law and stating how the relevant law has been applied to those particular issues. That's the framework around which the judgment must discharge an obligation. If one looks at substantial compliance in relation to that, one looks at it through the obligations identified in MIC, that someone has to have sufficient reasoning in relation to those matters to see how the tribunal has reached its conclusions in each of those respects. And so, while I don't appeal against and acknowledge that the tribunal, the EAT below, were right in approaching the judgment by adopting the test of saying, has there been substantial compliance with this obligatory requirement in relation to the employment tribunal, what I say is that the employment tribunal were in error because actually this judgment doesn't begin to comply with an obligation to give substantial compliance, in it that it doesn't adequately reason out critical bits of its reasoning, in particular as to how the law was to be applied as articulated in the legal obligations, and then applying it to the facts. My Lord, I think you looked as though you're about to ask me a question.
Yes, I haven't looked at paragraph 63 of Greenwood for years, if at all, but it never struck me that there was a real difference between Meek, a much older case, and English and Emery Reinbold. That the principle of both is, as Judge Hand sets out at the bottom of 62, that the party who lost must know why he lost. Basically.
Yes.
And there has to be enough, there have to be findings of fact and application of those findings of fact, application of law to those findings of fact, of sufficient clarity to enable the loser to understand why he lost.
Yes.
But it is, what does paragraph 63 tell us? Do you say that there's a more demanding test in tribunals because of what is now Rule 62.5?
No, I'm not suggesting that. I'm not necessarily focusing on the passage I read at the end of drawing distinction with the case of English, because if there is any subtlety in that distinction, on my appeal, we're not in the realm of that subtlety. We're so far from that degree of subtlety through distinction and reasons as to be not contendable. No, I'm not saying that how you've articulated isn't right. What I'm saying is that what that means is that when one's looking at the explanation of those reasons, it is necessary at least to see the reasoning being explained as to the findings of fact and how those are reached, and also as to the application of the law, which at least requires one to articulate, I would respectfully suggest, the test that's being applied and then apply it. And that's quite hard to see. And in some places, we would say quite clearly being misapplied when one looks at the way it's being mixed in with the facts.
But is this really a freestanding ground? This is what concerns me. I mean, suppose, and I know you don't accept the findings of fact are sufficiently clear, but suppose that they were. Why does it matter that the tribunal haven't set out the law? I mean, you'll be familiar, as I am, with tribunal judgments beyond number, where the tribunal judge, no doubt with the aid of word processing, sets out the statute and the leading cases on the particular area of the law. And then somebody in your position has to say, well, you set them out, but ignored them or forgot them. Here, the judge didn't do that. But why does that of itself matter?
If I've given the impression that I'm saying that of itself necessarily matters, I disavow it. I wouldn't begin to suggest that the fetter is so great that if you fail to articulate the particular reason, that the particular legal test, it necessarily raises a ground of appeal. If one can see from the reasoning that the indications are that the correct legal test has been self-directed and applied. And it's right to say that if this were just a freestanding ground of appeal on its own, I'd need to say the failure to articulate it as a ground of appeal. But what I'm really saying is that together with the substantive grounds shows that we can see that what's going on is that the tribunal hasn't done that on the face of the judgment, and we can't see that it's clearly self-directed itself as to the legal test to apply, because the glimmers we get of the legal test when we look at aspects of its reasoning indicate that it is misdirected itself in relation to matters. So if I can articulate the answer to your question in these terms, no one would suggest, and there are many dicta to this effect, that it's not good practice to do what the practice direction says. And you may ruefully say that your lives as Lord Justice of Appeals would be rendered rather easier if that rubric was followed in many cases. But it doesn't mean that it's an error not to do so. That I acknowledge. But substantial compliance means substantial compliance in understanding whether when you fail to do it, you actually can see that the necessary steps are really have actually been undertaken in the way that the tribunal has approached matters.
Where is all this going to take us if at the end of the day the employment tribunal's ultimate decision was that whistleblowing had nothing whatever to do with the dismissal of your client? Now, if that finding can stand, then the fact that there may have been arguable errors in relation to the treatment of some of the 35 or the 37 alleged disclosures isn't going to help, is it?
Well, I have two answers to that. The first is that his case wasn't only the dismissal, there was a detriment claim as well. And one of the aspects of detriment, and although I acknowledge there are findings about the detriment aspect of the case at a later stage, one of the aspects of detriment is that if you establish that there has been a protected disclosure and you do suffer a detriment, apart from dismissal, then it's for the employer to show the reasons. The second point is, I acknowledge that the tribunal make findings. My last ground of appeal attacks that, because before the tribunal, our case essentially was to say, we questioned who the decision maker was, whether or not it was only Mr. Nelly who made the decision in relation to matters, and also we placed before the tribunal the arguments to say that his mind may have been controlled as to the reasons by others who were doing so as a result of the protected disclosures. And in essence, we were saying that there was, because he was raising issues about the trading desk were expressing unhappiness about him in a way that led to his dismissal.
Yes, I mean, I appreciate that's how you put your case, but I mean, that was, as I understand it, rejected by the tribunal, who held that the decision to dismiss was taken by Mr. Nelly alone, and that he was uninfluenced by any questions of disclosure. I mean, if those findings stand, that is then surely conclusive against your client.
Well, firstly, I don't entirely accept that make an absolute clear finding that he did so. I appreciate that's a moot point between I and my learned friend.
Yeah.
The second point is, of course, if we're looking at the judgment, and we're looking at whether or not the tribunal has approached that correctly, I would say it's a fundamental problem in their approach to looking at the reasons. If they have simply not regarded there as being any form of protected disclosures at all, it raises a question mark about the approach that they take to considering his reasons. And it's an important factor then to consider whether or not they were actually in error in concluding that there were not protected disclosures being made. And that raises into question whether or not that in itself can stand as a freestanding conclusion in the case. And the answer to the first question that you raised to me, which is where does this go? Well, I acknowledge that I have to turn the entire judgment over, including that particular finding of fact, to progress the case on automatic confidence. Can't ignore that. But I say that I can on the basis of the appeal. What I, of course, have to accept that if I'm successful in doing that, there's really no option but for it to be remitted back for a rehearing.
Yes.
And I would say, it will come as no surprise, and I've run ahead of myself here, that if I'm right in what are fundamental errors in approach, it's a rehearing before a newly constituted tribunal, reapproaching these questions in a newly directed way.
Yes.
Yeah, thank you.
Sorry, that was a very long answer to
No,
Yeah,
I'm sorry, in a sense I took
it-
you out of your course, but I mean, I can see from your point of view, you want to build up a case beginning with, or trying to establish, numerous mistakes in relation to individual alleged disclosures, whereas another way of looking at it is to say, well, start at the end with the actual decision that was made to dismiss and what the reason given was for that dismissal.
Yes.
I don't find anything wrong with that.
Well, you've heard my why.
Yes, I have indeed. I'm not
So
asking.
anyway.
Thank you.
Can I only add to that? We are heading there eventually.
Yes.
Of course.
Yes. But
Sorry. Yes.
actually, before we leave this, as you plan the way ahead, I mean, the point identified by my lord seems to me rather important. The big issue for the tribunal in this case was what was the reason or principal reason for dismissal. And I haven't really focused on what other detriment claims there were, but they can't affect that question. What was the reason or principal reason for the dismissal? So there had to be a very clear focus on that issue. And if whistleblowing was not the reason or principal reason for dismissal, then you're in big trouble, aren't you?
Well, I acknowledge from the point of view of the unfair dismissal claim, he didn't have qualifying service. It can only succeed as a claim
Yes.
if he reaches the standard of it being the reason or the principal reason for his dismissal. However, one can't entirely isolate the process of disclosure, because his case was, even Mr. Nelly, he made disclosures to at a meeting that he had with him, which Mr. Nelly articulates as being the one at which, we'll come to it in the findings, about unhappiness and his relationship with people on the desk. And his case was, even at that stage, to the most senior person in the organisation where he was working, and high up the ranking in terms of the FCA accreditation, he was raising protected disclosures. So if that person is, if the tribunal has misdirected itself as to considering whether or not disclosures are being made, and that's undermining its approach, there's quite a fundamental question as to whether or not they were correctly to conclude that, for example, he wasn't making protected disclosures even to the person who was making that particular decision to dismiss. And so I acknowledge that they make findings about those reasons, but that doesn't entirely isolate them to be able to be a freestanding position. And what was clear is, at the point in time that this case was being argued, the law hadn't quite moved as far as it's moved now in some respects, in that now it's clear that the detriments, it's possible to run a case on the basis of the earlier detriments having a causative consequence of your dismissal, even though you don't say the dismissal itself is automatically unfair. That position wasn't being argued below, but what was being argued below, and this is why I say that one particular error of the judgment is the failure of the judgment really to articulate what was being submitted in terms of the law, was, as I've already expressed it, the fact that the complaints and the relationships on the emerging markets desk and the body of view there, that there were unworkable relationships, which is articulated as being the reasoning, not entirely, but the reasoning for the decision, was the product of disclosures being made and those being taken to compliance. And before the Employment Tribunal, we had set out.
Were there findings that the other people on the desk, Mr. Gooden or Mr. Blondin, that they knew that your client had taken these, had made these complaints or allegations to more senior people?
That's true. There are findings that that was the case, yes. But equally, there are findings effectively that nothing of what he's raising amounts to anything approaching a protected disclosure, and therefore we're being treated as being...
Yes, so I know there are those findings, but I thought you were saying that the earlier detriments, the unworkable. I thought you were just saying that the unworkable relationships within the team were, you say, caused in part by their unhappiness of him telling senior management or compliance about his views of their wrongdoing, and that's what made them unhappy with him.
Yes,
But what I'm asking is that right? Did they know that he was doing this?
Well, there was a factual issue that, if I recollect it properly, the tribunal don't directly articulate about the extent to which Mr. Cortellesi, who was more senior management, was aware of the fact that he'd gone to compliance at that particular point in time, and whether it was only Mr. Nelly who was aware of that. And people were cross-examined about whether or not there was a spread of knowledge in relation to that. The tribunal don't, I can go back to the judgment and refresh my memory in relation to this, don't make any explicit findings about that. But of course, going back to that, it wouldn't necessarily matter whether or not Mr. Cortellesi, for example, knew that Mr. Simpson had gone to compliance about it, if in fact he perfectly well appreciated that disclosures were being made that were raising issues about financial misconduct or potential financial misconduct on the trading desk, and that was something that was leading to expressions of there being fractured and toxic relationships between him and his colleagues in the form of the traders. So the answer to your question is that I don't necessarily, although we advance our case, I don't necessarily need that causative connection. What I need, if I'm running that particular case, is to say this, that obviously a primary case was to say that Mr. Nelly was perfectly aware that protected disclosures were being made, and that was in his head, and that was a case that the tribunal don't expressly find. But a secondary case that was being advanced, which appears in the skeleton argument, was the case that was being advanced as it then stood on the law arising out of Cooperative Group Baddeley and Royal May Group on Duty, about whether in the context of particularly whistleblowing, one could have a situation where, although the dismisser, the person who dismisses on the basis ostensibly of a set of reasons that appear to have got nothing to do with whistleblowing, they've done having been led to believe a state of affairs exists because someone else is acting in response to the whistleblowing. And that was an argument which was advanced by before the tribunal, and they don't actually specifically address that at all in terms of their judgment, which is why it's necessary, and I acknowledge this, to look at substantial compliance to say, well, were they thinking about that and rejecting it by their findings in relation to the reason? That doesn't quite work if the reason is said to be X, but actually, at least as a secondary argument is being said, well, that might be X in your head, and that's what you're articulating, but the reason that X has been put there is that others are responding to protected disclosures. Now, the tribunal although that was advanced out before the employment tribunal, they make no reference at all to that. And I acknowledge, of course, that the statutory test simply says that the reason has to be the making of a protected disclosure, and that's the principal reason. But the case law showed that one didn't simply at that stage look at the mind of the dismisser. And in fact, what happened subsequently, and as the reflection of the skeleton in this case, that had been the case on the EAT law that had been presented to the tribunal. By the time this came to the EAT, the Court of Appeal had looked at the matter and took possibly a slightly narrower view. And after my skeleton, before my learned friend's responsive skeleton, this matter was looked at by the Supreme Court, and Lord Wilson's judgment in the Supreme Court effectively, we'll come to it in a short while, says that it is open for the tribunal to conclude that even though the decision maker says X, it's open to the tribunal to reach a factual conclusion, that it can peer through that articulation and see that the real reason is something else. His judgment makes it clear that that's essentially a factual question, but that's a factual question however you articulate it as an argument, which was never addressed by the tribunal in the way that it was put or articulated as a question of law.
Well, so what I think you're saying then is that they didn't address it. They probably thought they didn't have to address it because of the findings that they'd made about the non-existence of any actual protected disclosure. So that whole subsequent debate didn't arise on the facts as they found. But what I think you're saying is that if they were wrong and if there was a protected disclosure, then the judgment is also defective in not going on to consider whether whatever Mr. Nelly was told was influenced by the protected disclosure that had been made, albeit to somebody else.
Yes, and I don't question that the tribunal makes findings about the reason. It does so, I think, from paragraph 160. But obviously, immediately before that, it said, well, basically, we've rejected all of these things as being protected disclosures. That would be the end of the case. But then, quite properly, it goes on to make findings. But I say those findings reflect the fact, once again, we can't see that direction in relation to the law, the application of those principles, in particular an argument that was being advanced before them as to why, even if they thought the decision maker was articulating X, it was still open to conclude that X was the product of disclosures being made other than to the decision maker themselves. Can I go back to, can I give you the comfort that it's been helpful, at least much of what I articulated will undoubtedly save time later on.
Yes.
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 Can I just go back to, again, the beginnings in relation to this case. And one thing which is, I would say, a fundamental error, which, with respect to the EAT, also falls into. And while I accept there's criticism made of the way the case is put, I acknowledge responsibility for that, in not grouping necessarily protected disclosures together, you'll see that I say that's not entirely fair criticism in relation to a core bit of the case. What I'm looking at here is the key question of whether or not it was right to approach this case only saying there are 37 independent articulated disclosures, and it's not possible to aggregate them. And that's whether the tribunal failed properly to direct itself as to the need to look at the possibility of aggregation of events. And for those purposes, again, not a case which is binding upon you, but was directly submitted to the Employment Tribunal, is the case of Norbrook Laboratories. And Norbrook Laboratories, before I take you to the case, I'm just going to take you, if I may, to the statute, because it's helpful to look at the statute before we look at the Norbrook. My submission will be that Norbrook raises some important points of principle in the way that, correctly I respect it, as to the way that one approaches the statute, which the tribunal entirely failed to direct themselves onto, despite the fact they've been invited to do so. To do that, can I just take you back to the statute very briefly? And you find the statute at the beginning of the bundle of authorities. And I appreciate it's a structure that you may be very familiar with. Of course, I know Lord Justice Bean will certainly be very familiar with. Section Part 4A of the Employment Rights Act creates a concept of protected disclosures. We find the protections for detriment and dismissal elsewhere, but the first step to be taken is determination of the existence of protected disclosures. And for these purposes, I haven't set out all the formulations of protected disclosures because the only relevant one was 4B and 4C. Although I just mentioned in passing that there were and are other grounds of protected disclosure which may be made not to the employer, but they're typically characterised by the fact, and this is important when we look at the statutory section, that in other cases, for example, if I choose to make an issue of protected disclosure to a newspaper, that I have to have reasonable grounds in the truth of its belief as to what I'm alleging. It's a rather higher hurdle. And when one looks at this level of disclosure, of a protected disclosure, perhaps understandably, a disclosure made in the workplace by an employee to their employer has a hurdle that respectfully we say is relatively low in terms of the criteria that have to be established. Not surprisingly, because the objective of the protection was to encourage people, I accept to make, responsible whistleblowing where they saw issues in the workplace. 43B then is the critical section, and you find that, I don't believe it's separately tabulated, so I think it's about the third page in your bundle. And 43B was amended in 2013 to add the requirement of public interest, and reads in these terms: in this part, a qualifying disclosure means any disclosure of information which in the reasonable belief of the worker making the disclosure is made in the public interest and tends to show one or more of the following. And then for these purposes, A or B, because we were dealing with regulatory market issues, criminal offence or failing to comply with any legal obligation were being intended to be the relevant criteria. But just deconstructing that, there are a couple of important points to note. We'll come back to the wider issues in relation to belief, because it's important to note that the question is the disclosure of information, and then that information, whether it's in the reasonable belief of the worker, that it tends to show. Tends is an interesting word because it doesn't absolutely require the information to demonstrate something. It appears to be drawn in a way that indicates that the information in the reasonable belief of the worker is tending only to show the existence of one of those things. And again, we'll come back to this. It's important to note that this is both in the past, both in the past and present tense in each of the sub-elements, because it's dealing with whether something is being committed, but importantly also the future tense, whether or not something is likely to be committed or likely to be a breach. So one can make a protected disclosure in anticipation of something happening, rather than merely the existence of it. We'll come back to reasonable belief and its important factor in relation to the employee. But the point I want to make when we go to Norbrook is this. It doesn't say in the section anywhere that the conveying of the information, the disclosure of information, has to be on one occasion. It just simply says that the employee has to disclose information. So that information could be disclosed on more than one occasion on the face of the section. Can I then just take you on to 43C? And this was a relevant condition for the purposes of this particular case, disclosure to employer or other responsible person. Qualifying disclosure is made in accordance with this section if the worker makes the disclosure to his employer. And I'll just pause to observe there. Of course, if your employer is a person, not a person, a single entity, individual, a human, well, it's going to be that individual. But if your employer is a corporate entity that will exist through its employees, officers and agents, then your disclosure inevitably will have to be to one of those, because there's no physical entity for which you to make that disclosure. The section doesn't say that that disclosure has to be made to the same person. So on the face of the two sections, a disclosure could consist of giving information on different occasions to different people, but together constitutes a protected disclosure.
Well, that makes life a bit difficult for the employer, because how is it supposed to join up the different bits of information in order to be able to do something about the disclosure?
Well, I think there are two answers to that. There's obviously the proactive exercise of doing something, but and I acknowledge that if someone has raised issues in different locations and has raised them with different people, the employer may legitimately say, well, we had a whistleblowing policy, and if the whistleblowing policy had engaged, we might have been able to do something about it, but these things have happened. But the purpose of this section, of these sections, is not about facilitating the action upon whistleblowing, it's about protecting the whistleblower. So if one turns it back round and says, well, maybe, and when we look at Norbrook, you'll see that the point I'm making is exactly the facts in Norbrook. If we turn it back round and see that one element of that step, let's say it's a specific allegation, but it lacks certain amounts of information, leads to reactive detriment to the individual, I'm afraid the intention of the legislation is to provide protection for that particular individual. Now, I appreciate that that when it comes to unfair dismissal, it still will be necessary to show that the principal reason for the dismissal is the making of the protected disclosure, but that doesn't mean that the protected disclosure might not have arisen as a consequence of individual acts during the progression of matters. So I draw a distinction between the difficulty for the employer in acting upon it and the conscious purpose in the legislation of creating a protection around someone who has done something, even though that may consist of more than one element and in terms of contact, and might consist of more than one communication. And what I say is it's not necessary, and the EAT seem to think it would be necessary, for individual communications to be in some way directly linked. It's not necessary to say, well, I told X this last week, and therefore you should know this. And we can see that in Norbrook. Can I take you to Norbrook? Because yes. I suppose it gives a practical example of the protection. It's tab 9 in your bundle of authorities. rather than take you to the head note, because of the summary of facts within the
I was just
judgment is
reading it. Can I just read through so that I've got the facts?
Of
Yeah.
course.
Yeah. Yes.
It's a judgment of Mrs. Justice Slade in the EAT, and at page 542, she sets out the outline of the relevant facts. And in particular, I'm going to focus on paragraph 6, but the outline of the relevant facts was a very cold winter of 2010, and particular concern in relation to the claimant about driving conditions. And so the area of protected disclosure one was concerned with was health and safety. And if one looks at paragraph 6, one sees this. The claimant sent 3 relevant emails to the employer. At 10:41 on the 30th of November, date correct, I apologise in the date of that, he emailed Alan Cuthbertson, the employee health and safety manager, as follows, and then there's a recital of the email. And the employment judge below, in that case, found that that couldn't of itself amount to a disclosure of information for the purposes of section 43. B. And then over the page we have, at paragraph 7, the claimant emailed again Mr. Cuthbertson in response to that again at 4 minutes past 12, expressing a hope that there would be some formal guidance and indicating that the team were under a lot of pressure to keep on the roads at the moment. It's dangerous. And we then get paragraph 8. As a result of the territory managers asking for clarification about their pay in the event of being snowed in, on the 6th of December, 1544, the claimant sent an email to a different employee, a member of the Human Resources Department. The employment judge set out the relevant parts of the email in paragraph 7 of the judgment. And what's noticeable is that there's no factual account there that those emails are linked. There's nothing to say that the email that's given to Human Resources says you need specifically look to the emails that I've given to Mr. Cuthbertson. And what the employment judge in that case found was that taking the 3 emails together could meet the statutory test for there to be a protected disclosure. And that was the subject of the appeal in relation to the particular case, as to whether or not that was consistent with the section. And again, not binding, of course, upon your lordships, but important in 2 respects. One, because it's a reasoning we say was right, but 2, it was a case that was being advanced and put before the employment tribunal to look at the way that the claimant had raised issues in relation to this case. Mrs. Justice Slade's discussion and consideration of this part of the case can be found at page 547.
This was after Cavendish Monroe, but before Kilrain.
It was, yes.
So the employer's case here is you take a magnifying glass to email number 1. It fails the test of being a disclosure of information rather than allegation. And then you must forget about it, looking at emails 2 and 3. The Employment Tribunal find that maybe email number 1 does fail the test taken on its own, but 2 and 3 clearly pass the test. You should consider the 3 together, and therefore the case can go forward.
Yes. And obviously the bit of the reasoning that was the employer's attack resting on Cavendish is, and it's a point we separately address in relation to the appeal, something which was subsequently departed from in the Court of Appeal, well, in the EAT in Kilrain and then in the Court of Appeal. But the critical point from my perspective is at 547, paragraph 22, acknowledging that the beginning of that paragraph deals with the Cavendish Monroe point. I say that between paragraphs C and D, where Mrs. Justice Slade picks up the account, she says this: the information must be of facts which, in the reasonable belief of the worker making the disclosure, tend to show that the health and safety of any individual has been, is being, or is likely to be endangered. An earlier communication can be read together with the later one as embedded in it, rendering the later communication a protected disclosure, even if taken on their own. They would not fall within section 45B1D. Accordingly, 2 communications can be said together to amount to protected disclosure. Whether they do is a question of fact. So, and the embedded point, which she put in inverted commas, is I don't read, because the facts weren't saying that this was the case, that it's embedded in the sense of directly referring to the earlier piece of communication, because that wasn't the case here. It wasn't the case that the email to Human Resources said, oh, and I said this to Mr. Cuthbertson a week ago in December.
I mean, that would be easy, wouldn't it? That would just be a matter of incorporation of one document by reference to another.
It would, yes. And you probably would never even need to consider the existence of the 2 communications, because you'd read the second one as if as the maker of it was clearly intending to communicate the earlier. So I say that Norbrook was an important case. I say that the principle is right. I acknowledge Lady Justice Rose's observation that it doesn't make an employer's life easy if, in fact, an individual might be able to point to communications and then say there was protection. But this is a protective regime for adverse effect, and obviously, ultimately, the making of the protected disclosure has to be the principal reason for a dismissal, or the reason for a detriment. It's not as though a protected disclosure or the making of it is in itself immediately a freestanding thing, so it will always still be necessary to go further. But it is important that this is drawn in a way that doesn't require those things to be separately articulated. And the EAT, in its judgment, appeared to adopt reasoning that requires some form of linkage between the communications. And I say that that's an error. There's no need for there to be any form of linkage.
The 2 sentences towards the end of Mrs. Justice Slade's paragraph 22.
Yes.
2 communications can, taken together, amount to a protected disclosure. Whether they do is a question of fact.
Yes.
Nothing wrong with that, is there? I expect Miss Mayhew doesn't dispute it.
Well, I hope not. I suppose the question that there's nothing wrong with that. That even to take my lordship's point about one communication that refers to another. What you have to read that as meaning is that 2 communications can be taken together to be a protected disclosure, even though they are made to different people, and they are not made cross-referring one to the other.
Right.
Now, I don't, my learned friend may take issue with that, but that's what I say is the critical aspect of that reasoning.
I mean, as to disclosures being made to different people within the corporate employer, I suppose you would say that's really just inherent in the fact that a corporate body has to act through agents of one kind or another, and there's no rule they can only act through one. You just have to look at the relevant principles of attribution in relation to any communication.
Yes.
To decide, or to answer the question, is it actually a disclosure to the company?
Yes, yes. And obviously there would be circumstances where I might say something to a fellow employee in a social occasion that wouldn't conceivably be considered to be said to them in their employment
in the right capacity, as it were, yes. So I can see, well, a lot of intricate and quite difficult questions may arise about attribution and the capacity in which somebody is being communicated with and matters of that sort. But those are all essentially questions of fact, once you've directed yourself correctly on the law.
Yes, and the key question there is to direct oneself essentially on the law,
Yeah.
that the communications together might consist of one. And that was clearly the way that Norbrook was, we'll come on to the closing submissions we made, but we presented Norbrook to the tribunal to say, and in particular, in the E18 notes that I spent a time of focus, and I apologise that I'm going to take you to exactly that point of focus, that we specifically focused on a series of communications with Mr. Cortelesi that we said taken together showed that there had been a Norbrook consistent disclosure of information and allegation. Now, we don't see the tribunal here even registering the existence of the Norbrook argument. They don't articulate it. The case was presented to them. They don't express a view in it. They don't say, well, we think that Norbrook requires some linkage and we don't see the linkage. They don't even expressly direct themselves about the possibility of considering things together. The closest they get to it is a passage that my learned friend relies upon at the very beginning of the judgment on ground one, which I'll take you to in a moment, which I say can't begin to sustain that particular level of reasoning. Can I, before I look at the particular things which were the focus of the argument for the AT on the failure to do this, just very briefly deal with the suggestion that that Norbrook appeared in a limited way before the employment tribunal below. This is a brief reference to the closing submissions that were being made. Can I give you the note and read the relevant part? So I think two of my lordships have got the relevant section. I'll read the relevant section.
Yes.
So it was one of those cases where I think my learned friend will probably remember it as well as I do, that the tribunal finished and had disclosed submissions pretty hard upon the evidence, and so there was one of those slightly mad, frantic exercises in trying to pull together something as part of submissions. And
actually, I've got it electronically, so I can pass that.
I've got it electronically as well, but I didn't bring it with me. Oh, I see.
So you could have mine.
Good. We all have it now.
I'm grateful. I don't need to spend very long upon it, but just to mention, in passing, before we deal with the Norbrook point, you'll see that at page 11 of the closing submissions, paragraph 25, 26 to 29, I'd set out the arguments based upon Baddeley and Royal Mail Group in duty about looking at the underlying reasons that then don't feature in the judgment. But the passage in relation to Norbrook is actually at paragraph 16 and then again later. So at paragraph 16, under the title of, that's on page 6, Elements of the Protected Disclosure, we broke down the sub-elements of the protected disclosure, and at paragraph 16.2, we refer to Norbrook and make the point that a protected disclosure may span a number of interactions where the whole is a protected disclosure or they form part of a sequence in respect they constitute elements appear only in parts. And I cited then to the tribunal in closing submissions the section from Norbrook in relation to that. And then, can I then just take you on? Because there was a central part of the way that the case was being put before the Employment Tribunal that related to interchanges between Mr. Simpson and Mr. Cortellesi on the 15th, 16th of September. And I'm not going to take you through these on the closing submissions, I'm going to take you to the judgment and how they deal with it. But if your Lordships just turn to page 14 and paragraph 38, you'll see that there was a subheading, 15th of September, protected disclosures in respect of market abuse through front running and unlawful trading practices. And then paragraphs 38 through until paragraph 50 set out some submissions based around the facts running beyond the communication of the 15th of September, but also an email that the claimant sent to Mr. Cortellesi on the 16th of September. And at paragraph 50, you'll see that we then make the submission. I take those points together, as in Norbrook Laboratories, one can see that flowing on the protected disclosure called of the 15th of September and the 16th of December, and the email of the 25th of September embeds, and obviously I've adopted the language of Mrs. Justice Slade in that, what he's raised in the references to things being done improperly.
Yes. All right. Well, you raised these points before the trial.
I did.
That's probably all we need from the closing submission.
It is all you need from the closing submission. I only deal with that because the Employment Tribunal, the Employment Appeal Tribunal find that there wasn't an adequate identification of the grouping together in the way that it was submitted, and I only deal with that to say, well, that's not quite right. The way that it was put did group things together on the basis of Norbrook, but the Tribunal don't actually address that argument. Can I then just, and it's purposeful in two ways, because it reflects some of the later arguments about misdirection, just look at the judgment of the Tribunal in that section that I was just alluding to in the closing submissions. And you find this in the Employment Tribunal's judgment at, it begins under a subheading Disclosure 20 on page 72 of the core bundle. It's paragraph 101 of the Employment Tribunal's judgment, and they have the heading Disclosure number 20, allegedly happened the same day in the Bluebird chat. And I've just taken you that for time reference purposes. That same day is a reference to the 17th of August. You can just see that in the preceding paragraph. And they then deal with communications between Mr. Cortellesi and Mr. Simpson on that day, recorded in a Bloomberg chat. But they go on then, at paragraph 104, to deal with this. At paragraph 104, you can see they say this. That afternoon, that was the August afternoon, following the telephone conversation with Mr. Cortellesi, the claimant sent home to his Gmail account various excerpts that he intended to form into an email to send to Mr. Cortellesi. One of those was an email quoted above of the 18th of August. Charlie, I'm not happy about what happened last week. So by the time it was sent to Mr. Cortellesi, it was not last week because the account 29 trade had happened between the 10th and 11th of August, about a month before. He sent the email to Mr. Cortellesi on the 16th of September, just after midday. It's stated, this is what we discussed today, which of course was yesterday by then. That's the Tribunal's comment. He seems to make an allegation about Kazakh's trade, which had occurred on the 14th of August, and yet the paragraph starts, earlier this week we were working in order for a client to sell Kazakh bonds. Thomas goes and hits a screen and bids my client lower, which of course he hits. There's a name for that practice. Now, the importance of this is that they've taken that email out of time sequence because it's an email that's being referred to, that's being sent on the 16th of September. And our case was, and the Tribunal, with respect to the Tribunal, make a very clear summary of the primary unlawful practice which was being alleged here of front-running the market. Our case was that that was a direct reference to front-running going on with someone taking information about the existence of an order for a client and using it on the screens in the market to gain a market advantage before the order is executed. Now, the reason I attached the importance to that was that if you turn on to paragraph 112...
When in that sentence, Thomas goes and hits a screen and bids my client lower, which of course he hits. Who is the he in that sentence? Is that Thomas or the client?
I think that's the client hit, so I think that means the client accepts that offer.
Yeah.
Yes.
So he accepts Thomas's offer rather than Mr. Simpson's offer.
Oh yes, it's not Mr. Simpson's involved in this. He's describing something that's happened.
Right.
So, but the point that what he's complaining about is that Thomas has already accessed the market with knowledge of the fact that an order is going to be placed, and that has influenced price.
Yes, but is that what the email says? There's a name for that practice. You say there's a name for that practice. It's front running and it's grossly improper and Thomas should be struck off. Or, as the Tribunal find, he's complaining that Thomas has cheated him, Mr. Simpson, out of what would otherwise have been a profitable piece of commission.
Well, there are two things going on. Can I be clear? Can I understand why, and this is exactly the danger of the Tribunal with my respectful submission, they isolated a submission that was being made where one should have read things together. The importance of that email is when you see it after what the Tribunal finds, because much of this was recorded in Bloomberg chats in text, is a communication, or in orally recorded in telephone calls, is a communication the day before that, on the 15th of September. So can I just come back to your first question in a moment? But to answer your second question, that's about motivation. I mean, it doesn't matter if my issue may be that I'm raising something that it may have a twofold purpose. I may be concerned, and this is Costerton in a nutshell, and I may be absolutely concerned that what I'm doing as market practice might be impacting on my personal commission. That may be my motivation.
No, I don't think that's the point, in respect. I think the point that I was edging to, and I think that my lord is making, is that he's not here complaining about front running at all. He's complaining about he was trying to make a deal with a client, in which case he would get the commission, and then Thomas goes and underbids him, and the client chooses Thomas's bid, and so Thomas makes the sale.
In which case I should go back to the answer to the first question, which I should complete and demonstrate why actually, when you see it applying the Norbert principle, he's quite clearly complaining about market mispractice. Can I ask you just to look at
what market mispractice?
Front running by using information ahead of an order. Can I just demonstrate that by looking at the later
So
findings?
what is the disclosure of what is the communication by him to the employer, which is a disclosure of front running?
The fact that information has been used before the order has been dealt with in order to gain market advantage. And can I just show you with the other paragraph, and you'll see why what he's following up with the email on is to give an example of what he's complained about, and Mr. Cortellesi understood he was complaining about. Can I ask you just to look at paragraph 112 on page 74? So this is under the heading disclosure number 21. And nearly a month on from the last, on the 15th of September, so the day before the email we've just looked at, it's said to have taken place in a Bloomberg chat and by email. There was a Bloomberg chat between Mr. Cortellesi and the claimant, and the tribunal note that the claimant returns to an old theme in relation to complaints about the desk. And then the important passage is this, it's the bottom of the page. Later, the claimant developed an allegation that strongly resembles front running, which therefore needs to be quoted. It's about the behaviour I hear. So how does that impact me? How it impacts me is I have stuff like someone comes in, a buyer of Ukrainian bronze, which is secret liquid, then we're bidding on screen or to some off-screen bookie, and it's moved against my client. What happens is, Mr. Cortellesi says, is what you're saying is that they're taking the information that you give them, then moving their screen against your client. Claimant, yeah, that's what happens. Steve, and then he goes on, Steve makes a ton of money in Ukraine, yeah, he's a god now, and I like, well, fuck man, I fed you guys information, I had some orders, so it doesn't show up in my numbers, because my guys didn't get executed, because they're showing preferences to other clients, so whether they get paid for it or not, they want to look like the big guy. Now, I acknowledge that he goes off to talk about the impact of the commission, but the point is that Mr. Cortellesi absolutely clearly understands that what he's saying is that information is being taken and used in the market against the interests of the client, and Mr. Cortellesi understands that from what's being articulated. Now, the importance of this is that the next day, the 16th of email, the 16th of September email, seen in that context, says, as we've just seen it, earlier this week we were working in order for a client to sell Cossack bonds. Thomas goes and hits the screen and bids my client lower, which of course he hits. There's a name for that practice. So we say that, and as the closing submissions make clear, you had to look at the fact that there was Mr. Cortellesi's understanding. We're dealing with people who are sophisticated traders in the market who understand the compliance obligations that they're subject to. We see Mr. Cortellesi absolutely understanding that what's being said is that information is being misused against the interest of the client. And the next day, we have something which the tribunal's critical of the claimant for in failing to provide information, him giving an example of a trade where he says that has happened.
But are you saying that the finding at 105 is a perverse finding of fact because the tribunal should have, why these things are, why disclosures 20 and 21 are in the order they are, it's a bit puzzling to me, but anyway, they should have realised that the previous day there had been a phone conversation of half an hour. They listened to the transcript. They find at 115 that Mr. Cortellesi did not consider that the claimant was actually describing front running with the hypothetical illustration. And then they find that on the 16th of September, the email saying there's a name for that practice, that in finding that that's a complaint about the claimant not getting paid for the trade, not front running, they were illegitimately atomizing the complaints.
Yes, and I hesitate about perversity because actually I put it in a slightly different way, because why I briefly took you to closing submissions is that we chronologically in the closing submission, referring to Norbrook, took that sequence of events in order, referring to the communications, and invited the tribunal to see that as being a process of making the allegation and supplying an example. The tribunal isolate out the 16th of September, put it in a different part of the judgment, but more fundamentally, they never address the legal submission that you're entitled to look at the existence of the information being supplied in more than one communication to consider whether or not, in the reasonable belief, whether or not that was information which, in the reasonable belief of the employee, tended to show the breach of a legal obligation.
Isn't there a danger of this all getting a bit overcomplicated? I mean, any communication of any kind has to be understood and interpreted in its context. And if the context is that there's been a previous email communication on the same topic between the same people the day before, I mean, it's just common sense. You can't look at one without the other. You don't really need a principal or an EAT authority to tell you that. I mean, it's just obvious.
Yes, well...
and I'm not sure, I mean, surely one can credit the tribunal with the common sense required to understand that much, at least.
And I wouldn't be so impertinent as to disabuse the client's common sense. And I acknowledge that obviously this is a slightly different context from even Norbrook, in that this is communication to the same person.
Between the same people, exactly.
Almost contemporaneously in time following on from particular events.
I mean, if there's one theme that runs through this ET judgment, it's that the claimant and Mr. Choudhury J were constantly in touch, much to the irritation, no doubt, of the latter, who was being bombarded with complaints on an almost daily basis. But I mean, so of course one has to look at the whole picture as well as at the individual items. But I'm not really clear where you're finding a material misdirection of a nature which actually vitiates the tribunal's findings of fact.
Well, can I answer that succinctly, briefly, which is to say, the error of approach is for the tribunal to have failed to direct itself that in considering whether or not a protected disclosure was being made, it could consider, and had to at least consider, if it was being invited to do so, whether discrete separate communications together could achieve the necessary communication of information to give rise to the reasonable belief on the part of the employee that they were making a protected disclosure. And the tribunal don't articulate Norbrook or that particular requirement. All they do is look at them in individual silos without considering them together. So I don't question their common sense about knowing the communication was there, but if you read the judgment, they deal with them in isolation. And my point, going back to substantial compliance with looking at the law and the reasons, is if they're invited on the law to consider that, as they specifically were in that line of communications there, although I appreciate the tribunal doesn't have to deal with every argument, it was important to at least direct themselves that they were not bound to consider what was said to be disclosures in isolation. And they seem to apply the test that it was necessary to look at each individual communication and look at the concept of information in isolation, and that was wrong.
Well, one could posit an example. You know, suppose that employee on day one, worker on day one, says to the compliance, what do you think about this hypothetical situation. Suppose that somebody was doing X, Y, and Z. Would that be wrong? And they say, yes, it would. And then in a separate email the next day, he says, oh, well, I just saw Bloggins doing exactly that. Now,
Yes.
neither of those separately might be a protected disclosure. First one because it's hypothetical, and the second one because it's not actually comprehensible. But if you add them together, then it clearly is a protected disclosure that Bloggins has just done what he was positing hypothetically the day before, and assuming that's illegal. So I can see that, as my lord says, common sense says you have to look at those together.
Yes.
But is that what you're saying happened here? I'm still not quite clear what you say you get from adding together the little email at 104 and the bigger email, or the Bloomberg chat at...
Yes. Well, the Tribunal's criticism about information in this particular aspect was to say that there was insufficient information being communicated. And obviously I'm critical about whether or not they draw a line between too rigid a line between an allegation and information. But their approach was to say that there wasn't sufficient communication of an issue to engage protected disclosure. Now, when they look at the communication in isolation about the Bloomberg chat on the 15th of September, they don't find that there's sufficient information in relation to that. But what I say is that when you see the 16th of September, if their criticism was that it lacked the specifics of referring to a particular transaction about which complaint was being made, the 16th of September made that good. So when you read the two together, you could see that he was saying inappropriately, market information is being taken and used against a client ahead of the transaction. Mr. Corsoloni understood that. The next day, the 16th of September, he gives a specific example of a trade where he says that links together. So I say that's, to take my ladyship's example, that's exactly what I say is happening here. And the Tribunal, whether it's common sense or the law, and one doesn't need to get too bogged down in relation to the principle of law in this particular case, because it isn't necessarily being made to different people, the Tribunal completely fail to consider the question of the statutory test of whether or not that test can be made out by the aggregation of communications in a practical sense, in particular as it was presented in closing submissions in that band of communication.
Well, Mr. Cortellesi gave evidence, didn't he?
He did.
I imagine you cross-examined him about this. You look at the email of 16th of September, paragraph 104 of the judgment. I would say there's a name for that practice is ambiguous, and your case is he is alluding to front running, which your client says he told Mr. Cortellesi about in the conversation of the previous day. So I imagine you put a question on the lines of you knew perfectly well what he was talking about, didn't you, Mr. Cortellesi? He was talking about front running.
Yes.
What did Mr. Cortellesi say?
Well, I'll be clear to my own friend, his case was that he didn't remember receiving a particular email. And if you notice...
I'm sure he was, but you show it to him. Yeah. So, what did he say he thought there's a name for that practice was referring to?
I don't think there was any issue, but that it was accepted that the name for that practice would be front running. What it's right to acknowledge that Mr. Cortellesi's case was he didn't register that email or the contents of that email. He didn't remember receiving it. And if you notice, the Tribunal don't actually make any specific finding at all about his response or understanding. When they deal with the communications, they deal only with the Bloomberg communication and what he understood that to mean. And that they find him to understand it, that earlier conversation, as not being about front running.
Well, but front running, as I understand it, is not about moving the market against the client. which is what they seem to be saying here. As I understand it, front running is you get a big order in which you know that order, the client's order, will move the market. I.e. move the market up because it's buying. You then make a smaller purchase yourself at the cheaper price, and then the market is moved by the client's purchase, and then you can sell what you bought at the higher price. But you haven't moved the market against the client. But here they seem to be talking about something different.
If I was sorry to say, and obviously I'm not giving evidence, but my understanding is that's not quite right.
It's both, isn't it?
Both.
Or it's a bit of one and a lot of the other. You buy at the cheaper price,
Yeah.
with the intention of selling later. That's what some people call insider trading, or
Yes, you
particular
use the knowledge that
kind
the
of
price will go up.
It may incidentally hurt the client because your small purchase moves the market up a bit. That's, as it were, count 2 on the indictment.
Yes.
But the most serious thing is count 1, that you're making an improper profit from your knowledge.
You're absolutely right. Count 1 is it's insider trading that you are using, and that's that would be the heinous aspect of it. But count 2 is, and that's why it's been particularly referred to there, that in the market, if you've used the information ahead, so to buy in that example, of course it could be selling in either direction,
Yeah.
but you entering the market will also impact the market's view. Now I appreciate it may or may not be significant. That isn't the point. The point is that you're using it in a way that may adversely affect your client's interests by using information about their own market intentions, A, for your own gain, that's the insider trading, but B, in a way that there's a conflict of interest that you might impact the market, even if it's slight, in harming them.
And am I right? I mean, these traders were acting not only on behalf of clients, but also on behalf of Cantor Fitzgerald itself.
Yes,
so they're in a position of impossible conflict of interest. How on earth do they avoid insider trading?
I'm sure my learned friend will take it as read that she doesn't accept that proposition. I'm sure.
I'm just puzzled at the thought of how you can be wearing those 2 hats simultaneously, and as it were, put out of your head everything you do every half minute.
Yes. The tribunal again very clearly articulate how that works. In that the traders had 2 things. They could be acting as an inter-dealer trader for the client and buying and selling on a client's behalf, but they also had a fund for the bank itself, for Cantors, and therefore they could go into the market and make an investment, effectively purchasing or selling. So obviously there was an importance in keeping your lines in that respect clear.
But there are no internal, or perhaps there are Chinese walls which stop one bit of the
I would expect that the
what the rest is up to.
regulator says that they have to be. I would have thought that would be pretty basic.
Well, look, we probably better not get... This is actually very interesting, but, or at least speaking for myself, but I mean, either information about insider trading or information about conflicts of interest, so on, either would be a qualifying disclosure. So we probably don't need to go too far down that route.
No.
Are we still on count 2? And count 2. Ground 2, aggregation.
We are. Can I just check my notes, because I think we're probably there to go to count 3. Can I just say this? So I appreciate this being streamed, and I'll just be absolutely clear. Protected disclosures are about protecting people that raise a disclosure. The truth of the disclosure is neither here nor there. So the tribunal had no concern with deciding whether or not there had been inappropriate market action in relation to this. And I acknowledge that wasn't an issue before the tribunal. And the question of Mr. Simpson's belief, as we can see from the case law, it wasn't even necessary for him reasonably to believe that the allegation was true. Actually, what he has to reasonably believe is that he's disclosing information that tends to show that it's true. Having a reasonable belief in the truth of the allegation is a higher burden that's only found in certain other forms of disclosure. So it's obviously important to have that context in the way that one approaches this. Can I just have a moment to look at...
of course.
2. Yes, but before I leave it, it's not really directly under 2. In fact, it appears as an argument effectively later as a ground relevant to that relevant belief. But while we've got the judgment open at this particular section, it's probably fact that what the tribunal do is, you'll recollect that the passage we were looking at related to the Bloomberg chat followed up by the email. Two things one can see later on as part of their misdirections. If you look at paragraph 115, the tribunal don't make any direct findings about the 16th of September email, other than that Mr. Simpson had sent it. That they make findings about this earlier conversation the day before, and they make this finding. They refer to the Bloomberg chat and Mr. Cortelesi's response to this conversation about the screen and the impact on orders. And then at 150, you can see in the last sentence they say, Mr. Cortelesi did not consider that the claimant with this hypothetical illustration was actually describing front running. He did not necessarily involve a regulatory breach and unlawful use of insider knowledge of an impending large purchase of Ukrainian bonds. We stress again it was hypothetical. The claimant was not identifying any particular trade here. And that's why I say it's important that you see the next day he actually does. And 2, you can see the tribunal's approach here is to look at it from the mindset of Mr. Cortelesi. Now I appreciate, and with respect, I acknowledge it's a fair point, that if an employer doesn't understand that something is a protected disclosure or act on it, well, that's an issue for the employer. But from the point of view of the protection, you don't look at the question of whether or not the person who's received it understood it to be a protected disclosure at all. It may be relevant to understanding whether or not the employee reasonably believed that the disclosure tended to show something, because it may be that the employer's reaction or the employer's perception gives you a helpful indication to form the view as to whether or not the employee could have reasonably believed it was tending to show something. But they've completely got the test wrong here. What they should be looking at is saying, did Mr. Simpson reasonably believe in telling Mr. Cortelesi this and following it up the next day with a specific example that he was conveying information that he reasonably believed tended to show a regulatory breach? That was the test for protected disclosure.
Well, yes, of course, you're right, but where does that take you? If it was not understood either by Mr. Cortelesi or by Mr. Neely when he came to make the dismissal decision, it was not understood to be an allegation of front running or similar malpractice, then why does it matter?
Oh, well, it does matter, because when it comes to give you a simple example, suppose that I have an office in this building, and the temperature in my office is constantly below the relevant health and safety regulations for a working environment. And I'm on the phone on a regular basis to the administration in order to get that corrected. And in the course of those communications, I mentioned the fact, because I'm not particularly familiar, but I've got some idea that health and safety legislation might be engaged. I mentioned the existence of health and safety and that there's a requirement about dealing with this. Suppose in my hypothetical example that I'm on probation and it's coming to the end of my probation, and the relevant manager says, that Reed, he's a complete pain. He's always ringing me up about the heating in his room. I may not have the slightest perception that that's a protected disclosure. But if that's the reason that I terminate your employment, the fact that you are articulating that it will still be an automatically unfair dismissal. I don't need to understand it's a protected disclosure.
No, of course that's right, but that's not the point I'm putting to you. If it's not suggested, is it, that Mr. Choudhury J or Mr. Neely or anybody else had any doubts that front running would be a breach of legal obligations? It's a question of what focusing on the dismissal decision, what were the reasons for the dismissal decision, feeding in duty, what if a line manager who influenced the dismissal decision was affected by the same reasons, then that may have effect on the result. But if the reasons for focusing on disclosures 2021, if the reason for dismissal is because the claimant is constantly making allegations of front running, then of course you win. But if the reason for dismissal is, as the tribunal found, that he's constantly making complaints about, for example, his own pay or aspects of his colleagues' behaviour which do not amount to information which, in the claimant's reasonable belief, tend to show that an obligation is breached, then you lose. And it seems to me rather hypothetical to focus on whether any one of these 37 disclosures tended in the claimant's mind to show that a legal obligation was being breached, if it was not understood by any of the decision makers to amount to that.
Yes, well, obviously, the way that the case was put at first instance was rather more challenging in terms of the individuals as to whether or not they entirely appreciated what was going on and whether or not their actions were motivated by the fact that the noise that was being generated was noise about complaints about market practices on the desk. And I acknowledge that the tribunal makes findings in relation to that. I think, as I articulated at the beginning of my submissions in response to the questions which were fairly put to me about dismissal, I don't think it's entirely possible in the way you approach this judgment in deciding whether or not there's substantial compliance with the rules to say, well, even if they should have concluded that there was a protected disclosure in this particular communication, you immediately leap to the end conclusion that there are findings there that support that not being the reason for the decision. Because I say, well, if they were right to conclude that there were protected disclosures, and interesting as I say, they don't make any direct finding about the 16th of September, that's an important finding of fact and law in how you approach the understanding of the events that unfold subsequently. And that's why I say you can't have confidence in the subsequent conclusions if the tribunal's approach to the foundations of considering the way that the case is addressed reveal cracks in the way that it's applying or directing itself to the law.
All right. Okay. Sorry, I'm as guilty of this as anybody. We keep putting points to you, but I think are you done with ground two, or is there more?
There's one very small point on ground two, and it's the tiniest of points which I'll just quickly deal with. It's paragraph 24 on my skeleton argument, which is that my learned friend, before the Employment Tribunal and before the EAT, and the EAT adopted this to some extent, argued that the tribunal did direct itself as to the composite approach, and one can see that they were applying it at the top of paragraph 37, page 62 of the judgment. Under the subheading paragraph 1, 27th of April, this was a composite feeling of disclosure starting on that date, with the claimant alleges that he said that there were improper practices with both the traders on the emerging markets desk how we would have included Steve Governor at this stage when he was still 4 months away from FCA approval is not clear. And then they go on to deal with the allegations in relation to Mr. Blondin and then subsequently wider. But it's not clear at all that what they're doing there is directing themselves to consider the composite approach, and they clearly don't consider it directly in those elements which I've directed your attention to later. And even the language of composite string of disclosures suggests that the disclosures have to be several, each freestanding, rather than existing together as one, which, without reiterating it, is the point of the Norbrook argument.
All right.
May I just have one moment?
Yes.
Because, in these rather unusual circumstances, I have to have WhatsApp to tell me if I've said something which I shouldn't have said in terms of the way the matters work. So I apologise for my
that's fine.
I'm fine. I don't need to correct anything that I've said. So.
You've got a green light.
No
Yes.
panicking messages.
No, well, I'm afraid that virtually there's yet to be an arm.
Electronic tugging of your gown.
So you can't possibly say that. Sad to relate, I've had that happen too often before at first instance. But anyway, I'm on ground 3.
Yes.
So, which is paragraph 25 of my skeleton argument.
Yes. This is the information point, and to an extent there's an overlap here on the some of the submissions I've made. It'll come as no surprise that critically in the information point features the section I've just looked at about the need to combine elements, the 15th of September and the 16th of September email. But before the Employment Tribunal, 2 cases were being referred to by the parties. One was Cavendish Monroe. That's the only case that the Employment Tribunal actually makes a reference to in their judgment. Cavendish Monroe, although I think when we perhaps don't need to look too closely at this fact, but when the subsequent case of Kilrain comes before the Court of Appeal, the conclusion in Cavendish Monroe was found to be correct, although some aspects of the reasoning were considered to be wrong. And essentially that case involved a solicitor's letter and whether or not a solicitor's letter on behalf of an individual could amount to a protected disclosure. And the approach in Cavendish Monroe could be read as saying that an allegation of itself couldn't amount to the conveying of information. In Kilrain, Mr. Justice Langstaff took a slightly different approach in terms of that and directed one back to the statutory test and noted that the statutory test, when it talked about information, didn't have a stark dichotomy between information and allegation. The question on the statutory test is whether or not it's information which, in the reasonable belief of the employee, tends to show, as I emphasised earlier. And before the Employment Tribunal, the attack, and no criticism of her for this, my learned friend, was to identify the individual elements and attack on the basis of lack of information. And the tribunal at various points made findings that there was a lack of information for the purposes of the section. Our position was, of course, to say
that it was necessary not to look at a dichotomy, but to adopt the Kilrain approach. The Kilrain approach subsequently effectively received the support in this court in the Kilrain judgment in Kilrain and the London Borough of Wandsworth, and the leading judgment in that case being given by, as he then was, Lord Justice Sales. I set out the whole of that passage in my skeleton argument of paragraph 27. Now, I don't raise issue that there is a factual issue here to be considered, and there's a factual and there's a subjective and an objective element to this. So there's a need to look at what's being communicated, to use it in its loosest term, to make findings about what is being communicated, and then to consider, and this is a statutory test, whether in the reasonable belief of the employee that tends to show the relevant criteria, whether it's breach, likely breach, present breach or past breach. So there's a need to consider what's happened, and then the need to consider the state of mind of the individual and their reasonable belief. And the two, I acknowledge, aren't entirely mutually exclusive, because clearly, if one looks at the conveying of some information, it would be possible to see that no one could have a reasonable belief from that particular information that the necessary test had been conveyed. What we don't have here is the tribunal clearly directing itself as to the need to break those elements down. And of course there's the secondary problem, which is why I say that in a sense you can't isolate this from the earlier criticisms I've made, for the example of the 15th of September communication, because it's important that when you look at the communications, if you are aggregating the communications, or said they have to be read together, the test has to be met by looking at that information as one. So the correct approach must have been here to take the example of those communications on the 15th of September and the 16th of September, to look at what was said in the Bloomberg chat, to look at the following email, all of which were being communicated by Mr. Simpson, and to say together, did those together give rise to information which, in the reasonable belief of Mr. Simpson, tended to show the breach of a legal obligation? We've already dealt with the separate and entirely irrelevant question of how they might have been perceived by the recipient of them, relevant only to whether or not that might be relevant to whether or not subsequent detriment or dismissal. And what we say we detect in the tribunal's approach is, and we're back to this fundamental problem in the first section, is we don't get anywhere a clear articulation of the caution in Kilrain. What we get is a reference to Cavendish, and we say that we can see that within the judgment, we can see that the tribunal is falling into the error of approaching it as if it were a stark dichotomy between allegation and information. And in the skeleton, we pick out various examples in a number of respects. So, for example, paragraph 155 in the judgment. And this is perhaps again another example of not reading things together.
Sorry, 155. Did you say?
Yes.
Yes, thank you.
And this is important to my Lady Lord Justice Rose's example of a question and then following up. 155, you'll see that they're looking here. This is down the track when Mr. Simpson's engaging directly with compliance, and he's speaking to Miss Mills, who's head of compliance in this respect. And 155 they say of Mr. Simpson, it's indicative that once again he's provided the specifics of the trade very slowly and piecemeal, with Miss Mills having to drag the information out of him 8 days later on the 29th of October. The account A trade is in fact the only trade whose details he ever did disclose: date, bond, trader, sales and the reference numbers. In sum, however, this cannot count as disclosures. It fails to satisfy 45B in two ways: information, not just a query, and reasonable belief. Now, what do they mean by that? Well, they seem to be going back to an earlier conversation on the 21st of October. And if you look at paragraph 154, under the heading disclosure number 32, it's said to be the claimant's email of the 21st of October to Annie Mills. However, it's stated to be an inquiry as opposed to be a disclosure of information. Could you let me know if the following information raises any issues? The scenario described seems to be the account A trade, which the claimant was not involved in. It was Steve Godden and Russell Scott. Again, there's a huge amount of speculation and supposition involved in the claimant's part. He's constructed a scenario based on overheard conversation, one-sided telephone calls, that could not support a reasonable belief that there was a breach of the FCA regulations. And you'll see as I make a separate point about this, that's entirely the wrong question, because he doesn't need to have a reasonable belief that there's been a breach. That's not the test for a protected disclosure. What they do at 155 is take the original proposition that it was a query and ignore what they found happened, that Mr. Simpson gave the details of the very same trade. So to give to flesh out the example, it's exactly that. It's saying, is there an issue about X, Y, and Z without specifying it? And then 9 days later, he says the details of the trade, which is the example that he gave in the earlier position. And the tribunal ignore the principle of looking at these points together. They isolate out and look at it as being a requirement of information that can't exist as that has to exist as a freestanding exercise, and then can't amount to an allegation, or in this context, a query, that read together with the later information can clearly amount to the giving of information. So we say that you can see it at 155, they're applying the erroneous Cavendish approach of looking at there need to be something which couldn't be a generic allegation.
Is the email of the 21st of October to Ms. Mills set out anywhere in the material we have? It's quite difficult to follow paragraph 154 without seeing what they were talking about.
No, it isn't.
All right.
Other than the tribunal take the scenario described as being the account A trade. So particular trades and clients before the employment tribunal were anonymised so that the public judgment wouldn't reveal people's transactions.
Yes.
But you can see that the A trade is the one that is then referred to in the 29th of October. So the tribunal themselves have made the connection that what he's described in the 21st of October email to compliance is a factual scenario which seems to be the account A trade. And then, although they describe it as being dragged out of him, they then find that on the 29th of October, he gives date, bond, trader, sales and reference numbers. What's hard to understand then is how one can conceivably conclude that someone has not complied with information and reasonable belief in circumstances where read together the information appears to be there in the context of, to take the example of a question being raised rhetorically as to whether or not there's an issue.
29th of October, was that a phone call?
I'm afraid I don't remember now the
Or
answer.
conversation, rather than a doc-
I don't remember. There were a number of meetings with compliance directly, and I don't remember now whether the 29th was. There is a chronology. If you bear with me a second, I'll maybe able to give you an answer to that.
All right, not to worry, Mr. Reed.
It was an email.
Yes.
Yes, he sent an email on the 29th of October with details and asked for further meeting with compliance. And then after that, there was a subsequent meeting with compliance on the 4th of November.
Okay. Any other examples under ground 3?
I'm just checking in relation to that. No. Although ground 3 has a subsequent subheading to the same effect, which is what's the mantle of information that you have to give. And that's paragraph 34 in the skeleton argument. Because obviously there's a question about that information test. And the hallmark to judge the information, it doesn't have a specific threshold in the legislation because it has to be information which in the reasonable belief of the employee tends to show. So the threshold is the establishment of their belief, that's the subjective element, and then the second objective element is determining whether or not that's a reasonable belief for them to uphold. And of course that doesn't mean that you have to achieve any particular level of particularity. The tribunal appear to have taken the approach that it could only amount to a protected disclosure to meet that requirement if there were details sufficient to say time, trader, client. You've just seen that in paragraph 155, where they said of that particular transaction that was the only one where he disclosed date, bond, trader, sales and reference numbers. And one finds earlier examples of them saying, well, there wasn't enough particularity. So, for example, at paragraph 77, end of disclosure 13, they say in relation to that, that the claimant's criticisms were, I'll find the relevant section for you now. I'm sorry, apologies, wrong reference. Let me give you paragraph 138 instead.
I thought the last line of 77 might be what you were
Yes.
Are you quite?
looking for.
You're quite. It is the last line. I do apologise. I've misread it too quickly. Sorry. Yep. So it is that's the section that I quoted my skeleton. I do apologise.
Yeah.
So they're essentially saying it's not enough to have a generalised. So one's in a spectrum. I acknowledge one's in a spectrum, but there could be the vaguest of allegations or references to something going on that might not engage anything that might tend to show. At the other end of the spectrum, there is date, time, transaction, parties, etc. And they have drawn a line by saying, unless it's at that end of the spectrum, it's not sufficient. But that's to misapply the test, because the test is directed, acknowledging that it's looking at what's communicated and then judging it on the basis of whether or not it's a reasonable belief. But it has to be approached by saying, did the claimant believe that what he was disclosing tended to show X, and then was that a reasonable belief? It doesn't lead one to the approach that there was any particular hurdle as to the communication of the information. I give two further examples in paragraph 34. I don't need to take you to the passages in the judgment, but you'll see the italicized text are both lifted from the tribunal's approach. So I say that's a failure of approach in the tribunal's part in the way that they've addressed these particular issues.
Well, isn't the last sentence of 77 referring to the problem in the claimant's case as presented to us, not the problem in what the claimant said to Mr. Bower-Roe?
Sorry, I'm being stupid. I didn't quite understand the question.
Perhaps I'm being stupid.
No, that is not possible.
The 77 and 78 are a pretty straightforward. Claimant says X, Bower-Roe says Y. We disbelieve the claimant on this point and believe Mr. Bower-Roe.
Yes.
There is no point of law in paragraph 77, 78, as it seems to me.
That I entirely accept.
Yeah.
That I entirely accept.
Yeah.
But here's the reason I point to these paragraphs. So the reason I point to these paragraphs is, in an ideal world, one would have had findings of fact about X, Y, and Z. One would then have had the articulation of the statutory test. One would have had the articulation of, as I've explained it, and there is no issue, the need to look at the disclosure of information from the perspective of the individual and then to consider whether or not that was reasonable belief. And in this case, we don't have that. What we have is elements of the law mingled in relation to matters. So I entirely accept that there's a factual finding there, but I can't really step round about what happened in that communication. I haven't gone to it to challenge that particular factual finding. I've gone to it because what the last sentence reveals is the way the tribunal's mindset is working. And going back to my original point, if one's driven to say, has there been substantial compliance in this case, where there's been a failure to properly direct oneself as to the statutory test, one's driven to look, in attack, but I humbly suggest that actually it's really about defence of the judgment, one's driven to try and find where the glimmers of that legal thinking are. And that's why I've gone to the sentence, because the sentence reveals that their approach is erroneous. So to turn my Lordship's question back as a submission, I appreciate that you say the problem with the appeal is that there are findings of fact. I don't demur from the fact that there are findings of fact. The problem with the judgment, which we say there's an error of law, is that can those findings of fact stand supported on the basis of the application of law that's been applied to them if we can't see that there's been substantial compliance with the application of law as they stand, because that's where there's an error in relation to the judgment. That's why I say, other than perhaps straying into the argument in relation to the 15th and 16th of December, where I wouldn't really shy away from the perversity of a conclusion that there was no protected disclosure there, that's why I say it's not really an attack, this case, on the findings of fact. It's that the findings of fact can't in isolation be seen to be supported about achieving substantial compliance with the law. But that's really my first point again. I'm not repeating it. But.
Right. Okay, is that ground 3 done?
So there's a subheading. There are two more subheadings quickly dealt with. Paragraph failure to direct self-information is future breaches, and that relates to the passage we've looked at 153 and through to 155, and in particular the tribunal there looked at the first meeting. So there's a sequence of events. Mr. Simpson meets with compliance on the 14th, There's then a meeting on the 21st, and then the email on the 29th. And there's a progressive process that by the 29th, a particular trade has got all the details. And at the 14th, they make the finding. He outlines scenarios and says of them the tribunal finally says of them they were hypothetical, and that he said, we've not crossed the line yet. The tribunal take that as meaning no breach. Well, that isn't again the test, as it were, because if what he understood he was saying, articulating, was that he was disclosing information that there was likely to be a breach, viewed from his perspective, that's the correct test. So the tribunal sort of take it as being, this is all about showing a belief that there had been a breach. And that isn't the statutory test. I think that's all that I wanted to say about ground 3. On paragraph 40, I reference so in Imperial College. It does no more than articulate it's an EAT decision, but articulate on what I've already articulated to be the relevant statutory test.
Yes.
Ground 4 was about the insider context, and again, I think that this is an EAT decision of Qureshi and Abattoir Bro Management, a judgment of the late Judge McMullen. It's a principle which the EAT accepted, and I don't think there's any issue about, that when one looks at disclosure, it's important to look at the context of the reasonable belief of someone from the view of the expertise of that particular individual. That, of course, works both ways, I acknowledge, because if I'm an expert in something and I make a disclosure which my expertise ought to have revealed I knew couldn't possibly tend to show a particular breach, it's held against me. But equally, if I'm articulating something which my expertise might believe that I'm articulating to someone else in the same context, they would understand to mean something, that underlines the fact that the communication between experts may be at a level that the external observer doesn't necessarily appreciate. And we put Qureshi before the Employment Tribunal, and obviously it's important context, and was, without going back over the same ground, that communication exchange with Mr. Cortellesi of the 15th, 16th of September, where our submission was that in the language of the regulated environment of traders, the use of the language, there's a name for that, was something which would have been understood as referring to market manipulation with that description. One didn't need to look at it, one didn't look at it from the view of the non-expertise, one looked at it from the view of someone who was versed in the regulatory requirements of the obligation. The importance of, so you'll find in the skeleton argument, I go back over the same ground about 14 and the 16th of September email. I don't obviously propose to repeat that. What I do specifically draw out, take it for the moment as read that I'm right that the two of them ought to be read together, the 15th and the 16th email. It's what the tribunal deal with this at paragraph 122. Can I just take you to 122 of the judgment? paragraph 120 to 122, there's a connection made here that isn't immediately apparent unless you've read the earlier section. 120 is dealing with the Kazakh trade that Mr. Simpson had raised issue about in the 16th of September email. You remember he'd said, I have a client who was looking for Kazakh bonds. The respondent called a witness who was actually Mr. Nelly's replacement, who had looked at the particular trade. This is post-events, and concluded that from those tickets there was no front-running in the transaction. Now, of course, whether there is or not is irrelevant to these particular purposes. The respondent's argument was to say, well, Mr. Simpson knew about this particular trade because he'd written the email, and he went to see compliance the day after the trade had happened and didn't mention the particular trade as being an issue. And at 122, you see the tribunal accept the respondent's contention, and they say this: if there was a serious belief that this was blatant front-running, it would have been the prime example to put before Mr. Moore with more urgency. He ultimately did raise concerns with Mr. Moore, as his email to Mr. Moore on the 15th of August was a general inquiry. It was not stated to be an urgent inquiry. Well, there's no statutory requirement of you having a serious belief. Obviously, the submission below, at first instance, was that here was someone on a probationary period who was finding themselves in an environment where they were unhappy about market practices, who was articulating their concerns progressively. But that's not really the point. The point is that the statutory test required one to look at the position of Mr. Simpson's expertise and knowledge and the reasonableness of his belief. Whether it was a serious belief is neither here nor there. And quite often in the judgment, we find the tribunal making broad comments about his perception of events and whether or not the fact that he hasn't urgently gone himself to compliance at an earlier stage is indicative that he didn't have a genuine belief that there was a breach. And as I've already made the point, genuine belief that there was a breach wasn't really the test. I'll slip by the second example, which is in relation to Mr. Godwin FCA trading, but can I just focus on the summation of these points at paragraph 50, because it's really drawing together. I deal with it in how the EAT rejected my submissions, because what I say you can see in the examples I'm pulling out is that failure on the part of the tribunal in their judgment to display that there has been substantive compliance with the application of the statutory test in looking at what's gone on. They don't direct themselves, and you can see that they are applying a different test rather than the question of whether or not the claimant believed he was disclosing information which tended to show the breach, and separately whether or not that was a reasonable belief. Having, without going back to it, looked at the collation of information together. That brings me to ground 5, and obviously these are all inextricably interrelated, and they're inextricably interrelated because that's really how the judgment is having to be attacked.
Yes.
And ground 5 is a failure to properly direct itself as to when and then to apply the reasonable belief test, the requirement. And this is a fundamental proposition about which there can be no argument, I think. It flows on from a very early case in the field, Babula and Waltham Forest College, a judgment of the Court of Appeal handed down, the leading judgment being given by the late late Lord Justice Wall, I think, yes. And the point about Babula and Waltham Forest is that Waltham Forest establishes the proposition that this aspect of the test is not about belief in the truth of the breach. That the relevant passage in Babula is, I think in the notes I put it as being paragraph 40, but it's actually paragraph 74 of the judgment. You find Babula at tab 4 of your bundle of authorities. And paragraph 74 and 75 of the leading judgment of Lord Justice Wall I don't perhaps for these purposes need to take you back to the underlying facts. Concerned a lecturer at a college making disclosures about the conduct of a previous lecturer in relation to Islamic studies. It focuses on the question of reasonable belief within the section. And 74 and 75 make it clear that what section 45B 43B requires, this is paragraph 74, each of the instances identified in 6 paragraphs of whistle allows to establish reasonable belief that the information being disclosed tends to show. So the point of Babula is from that early stage is you don't have to show that the allegation or raising of information was true. You don't have to show that you believed that it was true.
That's not what it says according to the head note, and that would be a bizarre thing. I mean, if I make a malicious allegation of theft against someone and I don't believe it's true, are you saying that's a protected disclosure?
Well, it is actually, because it. I mean.
Well, then if I'm fired for making...
Sorry, let me be clear about that. We have to be distinct about this. If I didn't have a reasonable belief that the information I was given tended to show something, obviously there might be a question about whether or not I knew that the information was completely wrong. But it used to be the case that if I was motivated by entire...
yes, it may be that I see someone pilfering from the till, say, and I know that lots of people pilfer from the till and I've never kicked up a fuss about it before, but because I've fallen out with that person, I then make a protected disclosure that they're pilfering from the till.
Yes.
The fact that I'm motivated by malice doesn't make any difference. But if I know that they're not actually pilfering from the till, that can't be a protected disclosure.
Well, I think strictly on the wording of the section, I think it could, but I don't need to go there in relation to this because my point in relation to it is that what I'm not drawing that distinction. I'm drawing the distinction that it's not about the end belief. Because, for example, I might not know that something is. I might not know that something is a breach of the obligation per se. I might not have a full picture, and that's what the tribunal finds in relation to here. So I might objectively not have a reasonable belief that there has been a breach because I didn't have enough information about it. But I'm still entitled to the protection of legislation if, with what I know about matters, I reasonably believe that the communication of that tends to show there's a breach. So to give you the example, if I saw a member of the security staff here picking out valuables from the scanning information, and I thought that what was going on was that they were being stolen, I might have come to completely the wrong conclusion in relation to that because I didn't know that actually there was an edict to the security staff that they had to remove certain things because they were dangerous in some way. And when properly looked at, there was no issue. But if I went to someone in the administration and said, I've seen these people doing this, and I think that they're stealing that particular material. I'm not motivated by malice. I'm completely wrong because there is no breach, but I'd still be protected.
Yeah, and you'd be protected even if you were motivated by malice. But if you hadn't actually seen them taking any of the
Yes.
things and you made the whole thing up,
Yes.
you can't be protected. Well,
I
as you
don't-
say, you don't have to go there. But
I don't
think
have to go
behaviour
there.
is an authority for the fact that you are.
Yes, I'm going to this authority for a far more limited purpose, because my far more limited purpose is that you don't have to believe specifically, you don't have to have a reasonable belief that what has happened has happened.
Well,
In terms of breach, if you
I thought
sorry.
No, I was going to say, I thought you did have to have a genuine belief, subjective. The question then, objectively, is whether that's a reasonable belief. But in the absence of a belief, a genuine belief, you don't get off the ground at all, do you?
Well, sorry, let me be clear. I articulated not very carefully. What you have to have is a genuine belief that you are disclosing information to show that there has been a breach.
And that can be grounds of suspicion, etc. It doesn't have to
Exactly
be.
right. What it doesn't, and this is the case as authority for, and that's all I go to it for, is what you don't have to show is that the basis of my supposition or my allegation is such that I had a reasonable belief that there was a breach.
We get that, don't we? The first two sentences of paragraph 79 of Lord Justice Wall actually is just reading the statute. Yeah. 43B1 uses the phrase tends to show, not to show. There's nothing which requires the whistleblower to be right. That's elementary stuff. Babula is interesting because the whistleblower was committing an error of law. One reads the head note and thinks, could this claim possibly have been rejected? But it was. But it was on this esoteric point that as to whether incitement to religious hatred was a criminal offence.
Was a crime or not at that particular point.
But there's nothing like that in the present case.
No. If in the present case there would be no issue that people, if it's front running, people would know that front running was an unlawful act. There's no question about that. So my point in relation to this, so I'm clear about it, is that what the tribunal seemed to do is to translate this into a requirement that he has to have reasonable grounds for a belief in the wrong, that the wrong has been committed.
He only has to have a reasonable belief that the facts tend to show that a wrong has been committed. Yes. But the belief has to be both genuine and reasonable.
Yes, has subjectively genuine and reasonable. But you see the tribunal approaching this in a different way, and I've given a number of examples in relation to this at paragraph 55, and I pick out examples from the judgment, in particular where the tribunal is looking about the fact that they say, well, he didn't really know the full picture, or he didn't know specifically what was going on. It's back to my example of the person that sees a security guard taking the products out. Well, that may or may not mean that there is no breach, but that's not the question for consideration in relation to whether or not Mr. Simpson was making protected disclosures. And so again, same point. I'm not questioning the factual finding. I'm taking the factual finding and saying what their comments are showing us is that there isn't substantial compliance with the legislative requirements. I haven't finished, but I'm conscious that I will. I might be another 15 minutes or so.
Well, if my colleagues are content, shall we just press on? And then.
As long as I've still got some water in this can.
Oh, right. Yes.
I'm sorry. I'm happy, of course, happy to go on, excuse me.
Okay, are we on to ground 6?
Well, can I, just so I'm clear, I won't take you through the examples at 55.1 through to 55.5. All of them are the same premise of the tribunal looking at the higher standard, and perhaps the best one, which sort of draws those threads together, is at the top of is at paragraph 56, which really underlines their erroneous approach in relation to this. The further tribunal's conclusion at paragraph 163, that having heard the claimant giving evidence over a long period of the tribunal, the equivocation suggests that the claimant cannot have had a reasonable belief in what he was alleging. So what they're focusing on there is the equivocation and their findings that he is slow in coming forward in relation to matters, and at one point they find that when he raises issues, he backs off in relation to matters. Now, that may be relevant to the question of whether or not he had a reasonable belief as to whether or not there had been a breach, but it's not relevant to the question of whether or not, looking at what he was disclosing at the point he was disclosing it, he had a reasonable belief that he was tending to show that there had been a breach. And so I say that shows that their substantial compliance with the legal test hasn't been directly engaged in relation to this. That brings us to ground 6. And ground 6 is failure to direct the tribunal as to the relevant test in respect of public interest. And without going back to the section, and you'll recollect that the amendments that were made, originally the motivation of a whistleblower could prevent it being a protective disclosure, and the amendments which were made to the legislation brought in a requirement that it was in the reasonable belief of the whistleblower that it was made in the public interest, and removed the motivation test and made that merely a criteria for reducing the compensation that whistleblower had. So I think slightly inelegantly in the way that it's drafted, with due respect to the drafters, we get two subjective tests which are then subject to an objective criteria. The subjective test is whether or not in relation to public interest, whether or not the employee believed that a disclosure was being made in the public interest, and then secondly, whether or not that was a reasonable belief that it was made in the public interest. And the tribunal, once again, this case was heard at a bit of a crux in the law as to the meaning of how that public interest test was to be applied. It had been, a case of Chesterton Global and Nur Mohammed had been heard in the EAT at that particular point in time, but hadn't been heard in the Court of Appeal, subsequently being heard in the Court of Appeal, Lord Justice Underhill giving the leading judgment. And how one approaches the question of public interest is quite a subtle exercise, because the question of what might be seen to be the public interest doesn't necessarily mean that it has to have wide-scale interest. It's clear that even a subset of the public who may be affected by something might engage the public interest criteria. But what's striking about this particular case is that the tribunal don't directly direct themselves again to the need to consider the statutory test by looking at the subjective belief of the individual, and then needing to consider whether or not objectively that's fair. We get glimmers of it appearing by reference to the public interest. And where we get those glimmers, and I entirely acknowledge my learned friend's point, because she would say, well, if the tribunal hasn't found there's an information, then you don't even get to second base, as it were. And obviously, without repeating them, I pray and aid my earlier submissions as to why they'd erred in not getting beyond the information point. But what we can see is that where they do engage with the public interest, they misinterpret the obligation. And in fairness to the tribunal, they didn't have the Court of Appeals judgment. And what's clear from the Court of Appeals judgment, and it comes back to the motivation question, is that it doesn't, that the belief doesn't have to form any part of the motivation. So if to go back to the example of me seeing the security guard removing items from the direction, suppose that I am entirely motivated by the fact that the security guards said something offensive to me last week, but for that I would have had absolutely no interest in raising with the administration of the building what was going on. My motivation is entirely retributive. It's neither here nor there. But I'd still, and it's obviously still the case that I have to show that I have that belief. If I can show that I also had the belief that it was in the public interest, and it would only be a section of the public, people that come into the building and pass through security, that could still amount to a necessary level of it being made in the public interest. And as Lord Justice Underhill found, it's paragraph 30 of the judgment in the Court of Appeal that I quote at paragraph 60 of the skeleton. The belief does not in fact have to form any part of the worker's motivation. The phrase in the belief is not the same as motivated by the belief. So I have to show I've got a belief that it's in the public interest. I have to show that's reasonable to believe that it's in the public interest. But slightly oddly, I don't have to show that I'm doing it out of a pious interest in the interest of the public. I can do it for any reason that I want to. And the tribunal get very confused about this, in my humble submission, because they focus on the commission and say, really, why you're raising all this material is your commission complaint. You see, it was put to me in argument earlier, you see yourself making less commission on a transaction because the market's been moved against your client by that market practice. Well, I might be motivated to raise I'm not suggesting my client was, but I might be motivated by the fact that my commission's being impacted upon to raise a matter that's showing that there is market abuse or insider trading. It's not hard to see that I could have a subjectively reasonable belief that it would be in the public interest or the section of the public who traded on that market to know if someone was manipulating a market with insider abuse. It's fairly self-evident. The tribunal seemed to focus on his self-interest and whether or not his self-interest in some way negates that particular position. So they've approached it in the wrong way. And you can see that, and I've given you examples again, at paragraphs 61.1, 61.2, 61.3. I should say that the example of paragraph 60, it said against me that the tribunal referred to a protected disclosure there and then referred to the fact that Mr. Simpson hadn't addressed it in his witness statement and therefore it didn't form part of the evidence and they rejected it, which as a finding of fact they're absolutely entitled to do because there was no evidence to support it. But the reason, going back to my earlier proposition, is not because I attack the finding of fact, it's because in a case where we're looking for substantial compliance, I look at what the tribunal said as an insight to their reasoning. And what the tribunal said is if this disclosure was really about underpaid commission, it could hardly be a qualified disclosure. It was not in the public interest but made for self-interest. Well, that's completely wrong. It can be entirely made for self-interest, but the individual can still have still be able to show that they believe that it was subjectively in the public interest and that was a reasonable belief. So I pick out those examples as identifying examples of that misapplication. Back to the same proposition, we'd ever see them engage with a fundamental question of a self-direction as to the correct test. That's all I wanted to say about ground 6. Ground 7 comes back to the point, back to the beginning.
Yes.
Yes.
I've already in part dealt with this. You may say that I'm arguing angels on the head of a pin in challenging whether or not there's a clear finding on the decision. I do question, obviously you're absolutely right, that it was a case where a fundamental part of the case turned on making clear findings of fact as to the reason for a dismissal, and particularly if the case was being advanced on the fact that other people's may have been motivated about presenting a picture of fractured relationships because disclosures had been made. It might have been sensible to have clearly articulated whether one was finding that there was one decision maker and they only made the one decision. And in fact, the only reference we get to Mr. Nelly making the decision is a slightly oblique reference in paragraph 160 of the judgment. So I'll give you the page reference.
Well, the tribunal accepted his evidence. He never looked at the claimant's notes at any stage before he decided to dismiss the claimant on 1st December.
Yes.
And the claimant had in fact been told to stay away from the 16th of November.
And then we get paragraphs 164. So we do make the forensic point that, and it was one of the evidential challenges below, that they don't make an express finding that he was the sole decision maker in relation to this. And obviously, as I've indicated, a case was being advanced on the basis of, as articulated in the skeleton, cooperative and Baddeley and Royal Mail and duty, that if the decision maker's view of the case, although professed to be for reason A, was actually because they'd led to believe that the scenario A was scenario A because other people motivated by the protected disclosures had led them to think that, it could still be a automatically unfair dismissal. So the 2 points about that is they never articulate that as being an argument. They never expressly articulate the position. And of course, part of that may be that they've hit firmly to the boundary, in their view, any allegation that there are any protected disclosures at all at the end of paragraph 163. Beginning of paragraph at page 85, where they say public interest disclosures, no hesitation finding that none of the above protected disclosures amount to disclosures under the Act. And so they're going on to look at the decision is going a stage further. I've already articulated why we say that you can't look at it in isolation when it's been so riddled through of a failure properly to direct itself. And that, at its heart, goes to the failure to address the question of whether or not the tribunal could properly then consider whether or not it needed to look through, even if it was accepting Mr. Nelly as not understanding a protected disclosure being made, making his decision because of fractured relationships, whether or not it was proper to look beneath that and say, well, the fractured relationships and the articulation that's being brought to him really are a reflection of the noise being generated by the protected disclosures. For completeness, my skeleton was drawn before the Supreme Court.
Yes.
And the relevant passage
Delete Court of Appeal, substitute Lord Wilson.
Yes, and the needle moves slightly more in favour of, with the greatest respect, I suppose, that Lord Wilson's speech clearly articulates what a tribunal can practically do. It perhaps doesn't necessarily articulate how one reaches that necessarily conclusion, other than the right conclusion must be in those types of case, in order to achieve the decision. The tribunal can see through the decision maker's reason and look at the reason underneath. And that is clearly the law. And to that extent, one went back to what the EAT had seemed to have said, perhaps rather less forensically than the Court of Appeal had said in duty.
You mentioned Mr. Neely a moment ago. Did he give evidence?
He did give evidence. Yes, he did. But yeah, he gave evidence in person.
Yeah.
So 2 witnesses gave evidence by video link,
Yes.
and Mr. Neely gave evidence in person. That's correct. And it's right to say I challenged him about his knowledge and whether or not he knew matters.
Yes. As you would. Right. Any questions
No, not
for Mr. Reed?
No.
All right. Thank you very much, Mr. Reed. We'll break off there and resume at 2:15.
Court rise.